Chapter 13, Nature and Rights of a Bona Fide Holder or a Purchaser for Value Without Notice. Section 126, Bona Fide Holder for Value Without Notice in general. The following provisions are found in the Negotiable Instruments Law and contain a correct statement of the law generally. A holder in due course is a holder who has taken the instrument under the following conditions. 1. That it is complete and regular upon its face. 2. That he became the holder of it before it was overdue, and without notice that it had been previously dishonored, if such was the fact. 3. That he took it in good faith and for value. 4. That at that time it was negotiated to him he had no notice of any infirmity in the instrument or defect in the title of the person negotiating it. A holder in due course holds the instrument free from any defect of title of prior parties, and free from defences available to prior parties among themselves, and may enforce payment of the instrument for the full amount thereof against all parties liable thereon. In the hands of any holder other than a holder in due course, a negotiable instrument is subject to the same defences as if it were non-negotiable, but a holder who derives his title through a holder in due course, and who is not himself a party to any fraud or illegality affecting the instrument, has all the rights of such former holder in respect of all parties prior to the latter. Every holder is deemed prima facie to be a holder in due course, but when it is shown that the title of any person who has negotiated the instrument was defective, the burden is on the holder to prove that he or some person under whom he claims acquired the title as a holder in due course. But the last mentioned rule does not apply in favor of a party who became bound on the instrument prior to the acquisition of such defective title. Section 127, Good Faith or Bona Fide. The term bona fide holder or holder in good faith, means a holder according to the law merchant, without knowledge or notice of equities of any sort which could be set up against a prior holder of the instrument. Absence of knowledge of the defense, when the instrument was taken, is the essential element in the matter of bona fides. That is, the holder, in order to be entitled to protection against offsets and equities and defenses based upon frauds, pleaded by prior parties, must have acquired the paper in good faith from his predecessor. If the holder's acquisition of the paper be in any respect fraudulent, he cannot claim the position of a bona fide holder. The Negotiable Instruments Law provides, the title of a person who negotiates an instrument is defective within the meaning of this act when he obtained the instrument, or any signature thereto, by fraud, duress, or force and fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. Section 128. Holder for value. We have taken up the consideration of the expression bona fide holder for value without notice, and bona fide purchaser for value without notice. This expression becomes important in case of equities or personal defenses. If there are certain equities or personal defenses against an instrument, a bona fide holder for value without notice may nevertheless recover against any party to the instrument. Of course, any party to an instrument who had an equity or personal defense can be recovered against by a bona fide holder for value without notice. But the bona fide holder for value cannot recover against one who has an absolute defense, for such defense attaches to the thing itself and can be set up against anybody. But, if the defense is a personal defense, it cannot be set up successfully. There is considerable in the expression bona fide holder for value. What is a holder for value and a bona fide holder without notice? A person is a holder for value who has given in return value, just the same as in any contract, or according to the Negotiable Instruments Law, value means valuable consideration. There are two different classes of cases, where there is some conflict of authority as to whether or not value has been given. One instance is where an instrument is given as collateral security. A not only makes his own note but gives the note of B as collateral security, and the better opinion is, that a note given as collateral security has been given for value, and a person who has an equity or a personal defense which he could set up against another could not set it up successfully in such a case, because the person who holds the security holds it for value. Some jurisdictions hold that the collateral note must be given at the time of the loan. They say it must be in forbearance to sue, or extension of time, in order that some consideration may arise for the giving of the security by the weight of authority. The better rule is to the effect that the holder of a collateral note is a holder for value and may recover from the parties liable upon the instrument. It is now settled in those states which have adopted the act that a note transferred before maturity to a holder in due course, as collateral security for a pre-existing debt, is transferred for value, and the holder takes it free from defenses or set-offs existing between the original parties. The second class of instruments is where a note is given for a pre-existing debt, for example when an account, or something of that kind comes due, a note is given for the debt. What was the consideration? All the goods have been bought and used, it is a debt. Can we say there has been a consideration? In some jurisdictions, the note itself is enough consideration. Other jurisdictions say that there must be some new consideration, forbearance or something of that nature. Still other jurisdictions hold that it must be an extinguishment of the debt. In other words, if A had an account of $50 and that account is due and unpaid, and A gives a promissory note for $50 and that is taken in extinguishment of the debt, and if afterward any proceeding is brought on that note, the holder of the note would be a holder for value. Or, if an extension of time has been given, then the holder of the instrument would be a holder for value. Conceding that it is an established rule that an antecedent or pre-existing debt constitutes value, there can be no question but that where paper is transferred in payment of a pre-existing debt, the transferee becomes a holder for value, and takes the paper free from all defenses and equities existing between the original parties. Those two classes of cases are the ones upon which there is a great, possibly the greatest, diversity of opinion. In all other cases it is whether or not value was given, that is, the principles of contract are applied. Where value has at any time been given for the instrument, the holder is deemed a holder for value in respect to all parties who became such prior to that time. Mere discount and credit do not of themselves constitute a bona fide purchaser for value. To occupy that position the holder must actually have parted with something of value for the note. Thus, where a bank discounted a note for a company, and credited it with the amount and the credit on account of other deposits, subsequently increasing so that at the time of suit on the note the bank had actually paid nothing for it, it was held not a purchaser for value, and that its remedy was to tender the note back to the company, and cancel the credit. Where the holder has a lien on the instrument, arising either from contract or by implication of law, he is deemed a holder for value to the extent of his lien. A banker's lien would protect a bank having possession of the bills or notes of a customer to the extent of the balance due such bank from such customer, and a transfer of such an instrument to any other holder as collateral security for the payment of a debt due such holder from the person who transfers the note, makes the holder a pledgee and gives him a lien to the extent of the debt. Section 129. Holder without notice. The third part of the principle is that the holder must be one without notice, a bona fide holder, a holder for value without notice. By that we mean that the person must not have any notice, either actual or constructive, of these defects. If he does have notice, he cannot recover against anyone who has these defenses. If a person takes an instrument knowing of the equities, they can be set up against him. The negotiable instruments law provides, where the transferee receives notice of any infirmity in the instrument or defect in the title of the person negotiating the same before he has paid the full amount agreed to be paid therefor, he will be deemed a holder in due course only to the extent of the amount theretofore paid by him. An amount paid for an instrument, if a trifling sum, may of itself establish notice. But it is difficult to lay down the exact line of demarcation and state what proportion the amount paid must bear to the face of the paper in order to charge the purchaser prima facie with notice or raise the presumption of bad faith on his part. But it may be said that the consideration should be so utterly trifling as to bear upon its face the impress of fraud, to leave open no reasonable conjecture but that the purchaser must have known, from the very nature of the facts, that they could not have originated from any but a corrupt source. The known solvency of prior parties would of course strengthen the argument of implied notice and bad faith wherever they were alleged. If the amount paid for the paper were not so insignificant as, per se, to charge the transferee with notice, it might still be so inadequate as to be a pregnant fact, to be given due consideration in connection with others in determining whether he should be charged with notice or not. If the amount which the holder offers to take for a negotiable instrument is insignificant as compared to its face value, it might be under the circumstances implied notice that there was something wrong about it, and if taken without inquiry, one should not be protected. For it is obvious that a bona fide owner would not throw away his property for a trifle, and that the purchaser acted in bad faith when he acquired it for comparatively nothing. To constitute notice of an infirmity in the instrument or defect in the title of the person negotiating the same, the person to whom it is negotiated must have had actual knowledge of the infirmity or defect, or knowledge of such facts that his action in taking the instrument amounted to bad faith. Actual knowledge of a defect or infirmity in an instrument on the part of the endorsee, although purchased by him, for value and otherwise in good faith, will destroy the protection which the law affords to a holder in due course. The fact that full value was given for an instrument will not benefit the holder where it appears that he had actual knowledge of the facts which impeach the title thereof or prevent a recovery thereon by him. Knowledge of the agent acting within the scope of his authority is notice to the principal. Now, there is one principle that is rather confusing in connection with a holder for value without notice, and yet it works out justice. And that is this principle, that if A receives an instrument from B and B was a bona fide holder for value without notice, even though A has notice when he receives it, if he is a holder for value, he may recover upon the instrument. That is, if B secures the instrument, say for $50, and there are certain equities against that instrument, as for example, the note has been procured by fraud. B does not have notice of that fraud when he gets that instrument. B having that instrument and being lawfully entitled to it can pass that on to anybody he desires, and if A has notice of the fraud which B did not have notice of, A can recover against those parties who did not have notice. What good would the instrument do B calling for $50 in his hands? His hands would be tied and he could not dispose of it until he disposed of it to somebody who did not have notice. The principle of the law merchant is that it can pass from hand to hand the same as money does. The law merchant says, yes, B can dispose of that instrument to anybody. It does not matter if that person has notice of the fraud. That person who had notice can recover upon the instrument. A bona fide holder for value without notice can dispose of the paper to a bona fide holder for value who has notice. Where an instrument payable on demand is negotiated an unreasonable length of time after its issue, the holder is not deemed a holder in due course. The same is true as to paper which is overdue. An instrument has been received and it is 1 month overdue. A looks at the instrument and says, why, that was due the 1st of February and this is the 1st of March. Why does the maker of that promissory note refuse to pay it? Why do those endorsers refuse to pay it? Do not misunderstand, because the instrument is overdue, that does not make it void. For if an instrument is all right before it is due, it is all right afterwards. If A receives an instrument payable to himself at maturity, he has a right to transfer that instrument after it is due. If A has good title to it, he can transfer it to anybody at any time. But, if A receives an instrument before it is due and receives it with notice of equities against it, such as fraud, etc., and he has notice of that before maturity, and then after the note becomes due and is not paid, X comes along and A offers it to him, and he says, that instrument is for $500, is it all right? And A says, yes, then X gives $500 for it. He is a bona fide holder for value but gets it after maturity. X gets no better title than A had. A had notice and X receiving it after maturity gets it also with notice, because A had notice and A cannot transfer any better title than he had. After maturity negotiable paper still passes from hand to hand ad infinitum until paid. Moreover, the endorser, after maturity, writes in the same form, and is bound only upon the same condition of demand upon the drawer and notice of non-payment, as any other endorser. The paper retains its commercial attributes, and circulates as such in the community. But there is this vital distinction between the rights of a transferee who received the paper before and of one who received it after maturity. The transferee of negotiable paper to whom it is transferred after maturity, acquires nothing but the actual right and title of the transferor. The transferee takes overdue paper subject to all the equities with which it was encumbered in the hands of the party from whom he received it. Thus if he took it from a thief, or finder, or from a bankrupt incapacitated by law to make the transfer, he cannot recover on it, inasmuch as the thief, finder, or bankrupt could not. Bills payable in installments are considered overdue in toto, when any installment is past due, but not from the fact that interest is past due. The position of a holder who takes a bill when overdue is this: he is a holder with notice. He may or may not be a holder for value and his rights will be regulated accordingly. He is a holder with notice for this reason: he takes a bill which, on the face of it, ought to have been paid. He is therefore bound to make two inquiries. 1. Has what ought to have been done really been done, i.e., has the bill in fact been discharged? 2. If not, why not? Is there any equity attaching thereto? i.e., was the title of the person who held it at maturity defective? If his title to the instrument was complete, it is immaterial that for some collateral reason, e.g., set off, he could not have enforced the bill against someone or more of the parties liable thereon. The rule that a party taking an overdue bill or note takes it subject to the equities to which the transferor is subject does not extend so far as to admit set-offs which might be available against the transferor. A set-off is not an equity, and the general rules state it is qualified and restricted to those equities arising out of the bill or note transaction itself, and the transferee is not subject to a set-off which would be good against the transferor, arising out of collateral matters.